All right. Would you mind just sharing your screen now, Mr. Simmons? Go ahead and click on share screen. Perfect. As well? Yep, that's good. All right. So, Dr. Sami, would you mind just sharing your screen now, Mr. Simmons? Okay. So
It is sharing.
This was the YouTube. Sorry. Here we go. So Dr. Sami muted, and Dr. Shakir also will be muted. All right. Let me admit everyone. All right. So if you go to the, just launch the presentation. There we go. All right. All right, let's go ahead and start. Bismillah ar-Rahman ar-Rahim. Assalamu alaikum wa rahmatullah. Thank you so much for joining in, and I'm sorry for the long delay in the waiting room. So let me start recording. Bismillah ar-Rahman ar-Rahim. Assalamu alaikum, everyone. Sorry for your long time in the waiting room. We had some issues with the Maghrib prayer, so we just gave some time for people to pray, and also until we were able to launch the live stream on YouTube. On behalf of the Muslim community and the Islamic Center of Central Missouri, I would like to welcome our guest tonight, Mr. Jason Simmons, who works in Cribbs & Simmons law firm. He is specialized in e-states, and he will be the best person to tell us about the legal perspective of planning for afterlife. So it's interesting from, human being natural trait that we used to run away and flee and avoid thinking about topics that bother us. But in fact, facing these topics and planning ahead of time will yield the best results, and from all perspectives, from ourselves and our families and our beneficiaries. So it's also interesting in the Islamic point of view, when we talk about death, it is something that we all going to face. So Allah, Almighty God, addresses the Prophet Muhammad, peace be upon him, that you are going to die and they are going to die. So this is a fact. No matter how long we're going to live, at some point we are going to leave this life. And this view should be also put in perspective of working and enjoying this life in a way that we express the usefulness of the bounties of Allah subhanahu wa ta'ala in this life. And one of the great examples is the statement of Ali ibn Abi Talib, who is the cousin of the Prophet Muhammad, peace be upon him, who said, live in this life as if you are going to live eternally. So plan, enjoy, do the good deeds in this life as you're going to live forever. And plan for the hereafter, the life after death, as if you're going to die tomorrow. So this is the balanced view of living this life and planning for the hereafter. That's why we may see the connection between the fact that we had financial planning and financial management workshop 2 weeks ago, and here we are today talking about death and planning for after death. So one of the greatest tools that we should all consider at this time, when people may be exposed more to sickness and the complication of sickness with COVID-19, the complication that may yield to death, is to plan to what happened to my family, to my wealth, to my beneficiaries after I pass away. So the will is one of the great tools that can guide what can happen after one passes away. God forbid, and may Allah bless all of us and extend our lives in good deeds. Joining Mr. Simmons will be Imam Shakir Hamoudi, our senior scholar and one of our imams, who will talk about the legal the Sharia Islamic perspective after covering the legal perspective too. And then we are going to have a Q&A session. Feel free to type your questions in the chat box. The chat box is private, and I only can see the questions, and I will try to moderate the discussion for the best time management sake. Mr. Simmons, welcome again, and please go ahead and start your presentation.
Thank you for having me this evening. This will be my first presentation that I give on Zoom, so if I'm not very polished, please forgive me. what I am going to talk about this evening was a topic that I was asked to present on, which is the will from Islamic and legal perspectives. I am probably self-identified as Christian. I'm not Muslim. So some of the things that I'll talk about, I really don't think that from the legal perspective that religion matters. It's how do we make a document that comports with an individual's personal beliefs, and of course everybody has their own freedom of religion. So with that said, just a quick background. Again, my name is Jason Simmons. I've been practicing estate and business planning in Columbia since May of 2003, and became a member of Cripps & Simmons in 2006. Our firm is focused almost exclusively on estate and business planning. We do probate matters and handle real estate transactions. What we don't do are basically anything else. So we are somewhat of a boutique firm or a specialized firm. And start with just kind of a brief explanation of why a will is important. If an individual dies without a will, they're said to have died intestate. Intestate succession deals with some default rules for who inherits your property upon your death. And let me take a look at this. It's in the right order, and I may have gotten some slides out of order, but this is kind of some background information. So intestate succession is the default rules for who inherits your property upon your death. The slide indicates that if you're a married individual and you have children only with your spouse, then the surviving spouse will receive the first $20,000 of property plus 50% of the balance. The remaining 50% will be divided equally among your children, and then that would be per stirpes. What per stirpes means is that if a child passes away, their share would then pass to their children. If you are married and have children with another person other than your existing spouse, meaning a second marriage type situation, then the surviving spouse receives 50% of the property that's subject to probate administration, and your children would receive the other 50%, and that would be divided among them equally, and again on a per stirpes basis. If you have no spouse, meaning maybe you're the second spouse to die, then all of your property gets split equally between your children. And if you have a child that predeceased you and they have children, then their share would be divided among their descendants. If you have no descendants and you are not married, then your property gets split equally among the parents and your siblings, and again on a per stirpes basis. If somebody's said to have died testate, then that's basically you've died with a will, and you implement your rules for who inherits your property upon your death. And again, it's important to realize that wills in Missouri only cover probate property. We'll talk a little bit about that in a moment. So wills, what they do and do not do. They only control the probate estate. They do not avoid probate. In fact, your will is not valid unless and until it is admitted to probate and determined to be your last will and testament. In Missouri, a will does not trump joint ownership or beneficiary designations. So for example, if you own your bank account jointly with your spouse, then upon the death of the first joint owner, it will pass to the survivor. Similarly, if you have a joint bank account, that is going to pass to the joint owner, and that is not going to be subject to probate administration. If you have life insurance or you have retirement accounts in which you've named a beneficiary, then those beneficiary designations are going to control where that property goes. And you can have beneficiary designations on pretty much any type of property in Missouri. So with respect to real estate, it would be called a beneficiary deed. With respect to your automobiles, it's called a TOD, or a transfer on death designation. Bank accounts and financial accounts are going to have POD, which is just a pay on death. So all different ways to easily avoid probate if that's what you wish to do. Having a will, one of the things that you do in a will, it's the only way to nominate a guardian for your minor children in the event that you have them. And it's important to understand it's a small distinction. You're not naming the guardian, you are nominating a guardian. So you're expressing to the probate court your desire as to who's going to serve as the guardian for your minor children. That guardian still has to make application to the probate court and still has to be formally appointed and go through the process of establishing a guardianship for a minor child.
Sorry to interrupt you. Just to be on the same page, what do you mean by probate?
So probate is a division of the court system. In the court system, you have a criminal division, you have a civil division, and then you have a probate division. You can also have a family law court. And probate matters are the types of matters that deal with guardianships of children as well as adults who aren't able to make their own medical or replacement decisions, conservatorships for individuals who are not able to manage their finances, again, whether they be minors and they have a legal disability or whether they be over the age of 18 and have some sort of a physical or mental disability that prevents them from managing their money. The probate division does handle the administrations of wills or the administration of property if somebody dies without a will. The other things that the probate division will handle are going to be mental health courts as well as trust matters. So it's the subject matter of the local court is going to be limited to those types of probate matters.
Thanks so much.
You're welcome. So when we start talking about a will, it's important to understand who the parties are. The person making the last will and testament, a testator is simply a male individual that's making a will, and a testatrix is simply a female. Latin derivatives, it's carried over through the common law. It's something that my office has continued to use. It is something that we are considering whether or not we just refer to the person as a will maker. There's no formal requirement that those terms be used, but you'll see those quite often, and that's what they mean. It's simply the individual that's signing the will. The personal representative that's named or nominated in the will is simply the person that's responsible for managing the estate and its property. You have the beneficiaries. Those are going to be the persons or organizations who will receive the property, either by a specific bequest or devise or as part of the residue. A specific bequest is simply the transfer of tangible personal property or anything other than real estate. A devise is simply a reference to real estate. And then if you do have minor children that you're concerned with, then you're going to nominate guardians. And again, these are going to be the individual who is nominated to take care of the minor children of the testator or the testatrix. Kind of a typical outline for a last will and testament. You're going to have the caption. This is simply the title of the document, Last Will and Testament of John Q. Testator. You don't have to use the terms last or testament. You could simply say will of John Q. Testator. There's nothing in Missouri law that requires that, but again, sometimes old habits are hard to break, so we simply term them last will and testament. Then you'll have an introductory clause. This introductory clause should identify the maker of the will, should include some statement that the individual is intending to create a last will and testament. Typically, it should include a statement of domicile, so they are a resident of Boone County, Missouri. The purpose for that is to establish that the document's being made in Missouri and that for purposes of determining whether or not the will is validly executed or not, they know which state's laws to look at to make that determination. Typically, you're going to include a statement that all prior wills that may have been made are revoked. And this is somewhere where you can include a statement of wishes concerning faith or beliefs. It can also be set aside as its own separate article, but if those things are important to you and you wish to set forth kind of where you're coming from and what your wishes and desires are, this would be an area that you could include this, or again, just generally maybe right after the introductory clause, maybe make it the first article of the will. That way your wishes can be made known. The next article that's typically going to be viewed is going to be an authorization for payment of expenses. These are going to be lawful debts. So if you owed somebody money that you had borrowed to purchase something, or your regular utility bills, your car insurance, those sorts of things, then you're instructing that your lawful debts be paid. You're typically going to request and authorize the personal representative to pay your funeral expenses, whatever that may consist of. And then you're also going to give specific instruction that taxes that you owe should be paid. Typically, these are going to be legacy taxes, inheritance, transfer and succession taxes. The state of Missouri has an estate tax, but it only applies if and when the federal government will give a credit for the tax paid to the states. The Internal Revenue Service has gotten rid of that credit probably 15 plus years ago, 20 years ago, so that Missouri no longer has an estate tax because there's not a credit given for payments to the state. The current federal estate tax exemption amount does kick in at $11.58 million, and that number is indexed to inflation. The next provision that we typically see in documents that are prepared in my office, we include a paragraph that talks about the disposition of tangible personal property. That statute reference section 474.333 indicates that the person making the will can provide a written list. That written list can simply identify what the item of tangible personal property is, and then can indicate who's supposed to receive it. This would be something like maybe there's a family necklace, or tool collection, or baseball card collection, anything like that, and you can simply indicate who's to receive that property. And if you want to make a change, then you simply get rid of the old list, you write down a new list, and you identify who's to receive what. And those individuals don't necessarily have to be otherwise named in the will, and they can be collateral relatives, friends, or anybody. The next article is typically going to talk about specific bequest. Again, this would be for personal property or specific devices. So if you wanted to leave a particular piece of real estate to one beneficiary, then you could go ahead and set that forth in a specific article. And similarly for personal property, if you wanted to say my automobiles are to go to this individual, or the contents of my home are to go to this individual, you can go ahead and do that. Then typically you're going to have a disposition of the residue, so all the residue and remainder of my estate. I think it's good practice to indicate who your primary beneficiaries are. Depending upon the number and the quantity, then you may want to provide for contingent beneficiaries. And then again, depending upon the number and the quantity of your primary and your contingent beneficiaries, you may want to identify who are going to be the takers in default. So kind of a quick example of this would be, again, just based on what many of my clients do, they'll identify that they wish to leave everything to their spouse if they survive them. If the spouse does not survive, then everything is split equally between my two children. And in the event that I'm not survived by children or any other descendants, then they choose to leave their property to other family members or charitable organization, or something along those lines. Another thing that I typically will recommend that if we have a situation where there may be minor beneficiaries that would be taking under the will, would be an authorization for custodial transfers. So Missouri Uniform Transfers to Minors Act basically allows somebody to be identified as a custodian. That individual is going to be over the age of 18. They would receive that property as the legal custodian and have the right to sell, transfer, manage, distribute that asset for the benefit of the minor child, and would continue to do that until they turn 21. So it's kind of a way to avoid a minor guardianship proceeding by naming somebody as a guardian. Realize that you can create a trust for the benefit of minor children in a last will and testament. That type of a trust is called a testamentary trust, in which you would designate who's going to manage the property for the benefit of the minor children. It's not something that I do a lot of. It is something that I will typically work with younger families in which the bulk of their assets are going to include a home, probably has a mortgage against it, smaller bank accounts, and a fair amount of life insurance and or retirement accounts. The next article that's going to be included in a will is going to include powers of administration. In this type of an article, you can identify whether or not the personal representative is to be supervised by the court, or whether or not they're going to be authorized to conduct the administration independently. What this basically means is in a supervised administration, if the personal representative wants to do anything with respect to the property that's in the estate, then they have to get the court's permission. So if they wanted to keep the home, then they'd have to file a motion to take charge of real property that would authorize the payment of the utility bills associated with the property, the payment of taxes, the payment of insurance on the property, and those sorts of things. If somebody's going to be living there, then they'd be authorized to do that. If they wanted to sell some of the personal property, whether it be a vehicle or the contents of the home, then they'd have to file a motion for that. If they wanted to sell the real property, then they'd have to file a separate motion for that. So basically, the court grants its permission on everything that needs to be done with respect to the assets of the estate. If there's a business that's owned by the decedent, then they need to file a petition to take charge of the business and to continue that business. That would include the power to pay employees, and again, just generally conduct the business of the decedent so that its value can be preserved. One of the things that may make a difference, depending upon the personal preference of the will maker, is going to be the investment powers that are included. Sometimes individuals are going to be environmentally conscious. Sometimes individuals are going to be driven by religious beliefs that they should only invest in certain types of assets and businesses. So we can include those types of powers within the document. And to the extent that any of those powers would be maybe not in complete agreement with the Missouri Prudent Investor Act, then we would want to go ahead and include some specific powers that would hopefully authorize that individual to engage in those types of activities without repercussion of being held responsible by the court in the event that there's a downturn in the value of the estate assets. Another document or another provision that we're now including in our wills, Missouri Fiduciary Access to Digital Assets Act. So those individuals who have digital accounts, whether that be a Facebook account or some other sort of a social media account, maybe Bitcoin or other sort of digital currency, then that would authorize the personal representative to manage those assets in accordance with the agreement with the company that is ultimately going to be in charge of controlling access to those accounts. The next article that we include in our wills is going to be the nomination of a personal representative. Typically, again, in my documents that we prepare at my office, we're going to list a primary individual, and then we're going to have one or maybe more contingent individuals who are going to be allowed to serve as the personal representative. And then we also include a waiver of a surety bond. That's basically just telling the court that so that we can reduce the cost and expense of administering the estate, that we want to go ahead and waive the requirement of posting a surety bond, which is just an insurance policy that's purchased from a commercial insurance agency that guarantees that the personal representative is not going to waste or abscond with the funds and would use them in an appropriate manner. The next provision that's probably going to be included in our wills, for again, just a simple or a basic will, is going to be the nomination of a guardian for minor children. Again, it's my typical practice that we name a primary guardian, and then we name a contingent, and maybe even a second alternate, depending upon the facts and circumstances. This is a type of situation where normally I name one person. If you're going to be naming a sibling or something along those lines, I name the sibling and maybe not necessarily their spouse, because in the event that they were to get divorced in the future, then you've created a custody battle to the extent that you've named them or nominated them as co-guardians. So that's my general rule of thumb. If we're going up the chain to where maybe we're naming some parents, that's less of an issue because both of them are blood relatives, and it's not just something that's created by marriage. Having an attestation clause in Missouri means that there's going to be some specific language in the terms of the trust, and it's basically going to be a statement to the effect that the individual has created the last will and testament, that they have asked two witnesses to witness their signature, and that they're doing so in the presence of the testator or the testatrix. This is something that can get a bit tricky. This must be signed in the presence of two disinterested witnesses for the will to be valid. If it is an interested witness, basically somebody who's going to receive property under the terms of the will, then it's only going to be effective as long as the disposition of the property is consistent with what their intestate share would be. So if you remember back towards the beginning, we talked about who would receive what in the event that somebody died without a will. If you wanted to leave more to that person than what they would be entitled to, then they most definitely should not be a witness to the will. If the will does contain a proper attestation clause and is properly signed before two disinterested witnesses, then there's going to be a presumption that the will was duly executed. The final provision that I include in my wills is going to be the self-proving clause. And again, this is some specific language that's required by statute. Again, what this language is going to say is that the person that made the will appeared along with the two witnesses, that each one of them signed in the presence of the other, and that the will maker indicated that it was their last will and testament, and that it was free of any undue influence or duress, and that they were of sound and disposing mind and body. Those three individuals are going to sign the will, and then the notary is going to notarize their signatures. If it's done without the self-proving clause, it being in the will, then again, there's a presumption that the will was duly executed and valid, but at the time that the will maker has passed away and at the time that their will is being admitted to probate, then the witnesses have to be located again, and then they have to sign a commission that would be returned to the probate clerk, stating that, again, basically the same information that would be in the self-proving clause, was that the individual appeared before them, expressed that this was their last will and testament, that they were of sound and disposing mind and body, and that the will was in fact their last will and testament. Once that gets done and those commissions get returned, then the court would admit the will to probate. One of the things that I was asked to talk about in this document is what happens to an individual's body when they pass away. You'll notice that one of the things that I did not mention or did not include in my will is how an individual is to be buried. The reason for that is that to have your will admitted to probate, you typically have to, not typically, it's required, you have to prove that you are in fact deceased. And the only way that the courts do that in Missouri is through having a valid state-issued death certificate. While those don't always take a tremendous amount of time to get, they can take a week or so, even in a good situation. And have had situations in which it's been several months, 4, 5, 6 months, whenever there's been some circumstances that were suspicious concerning the death, and being able to get a death certificate, and that prevents us from being able to open the probate estate. That will is not valid and is not binding on anybody, and the personal representative is not appointed unless and until the will is admitted to probate and the court makes an order appointing that individual. So normally the burial and those final arrangements need to be taken care of, or desired to be taken care of much more before that will is admitted to probate. In order to be able to take care of those types of instructions, then the general document that my clients will use is a healthcare declaration and a durable power of attorney for healthcare decisions. This is sometimes going to be referred to as a living will or a healthcare directive or a healthcare declaration. The power of attorney for healthcare decisions is always going to be springing, meaning that the individual that you name to make decisions on your behalf when you are not, well, when those need to be made, is only going to be able to do so when you're not capable of making your own medical decisions. In Missouri, if you are going to authorize the withdrawal or the withholding of food or water, that must be specifically stated in the terms of your healthcare declaration. These requirements do vary from state to state. So if you are an individual who's going to be residing in multiple states, it may make sense to have more than one document to make sure that your family members and the individuals that you're going to have make decisions, as well as the expression of your interest, are going to be carried out in each state that you might be found in. Alternatively, if you currently live in Missouri, if you move to another state, it's always a good idea to have your documents reviewed to make sure that they meet the requirements of the new state. And this is my recommended location for your burial instructions. And these types of instructions should be consistent with your religious and personal beliefs. It's my understanding under Sharia law that burial is to occur within the following evening of death. And that's why it's important to include these types of provisions in this document, because that can help the individual carry out those instructions. Typically, a healthcare declaration, durable power of attorney for healthcare decision is in 2 parts. The healthcare directive is going to be end-of-life decisions. So if you sustain a substantial and irreversible loss of mental capacity and not able to eat and drink without medical assistance, and it's highly unlikely that you're going to be able to regain that ability to eat and drink without medical assistance, or if you've been diagnosed with an incurable or irreversible condition, which is likely to cause your death within a short period of time, then you can instruct artificial hydration, nutrition, and CPR and all other life-sustaining treatment to be withheld. In the event that you don't have any of those types of circumstances, but rather you are not able to make your own choices regarding your healthcare decisions, then the durable power of attorney for healthcare decisions would then kick in. And again, we normally name one person and then have a first alternate and a second alternate. Some other healthcare issues that may need to be addressed by somebody that's addressing these types of end-of-life planning matters. Missouri law does allow for what's known as an outside of the hospital do not resuscitate order. The statute requires that this piece, or that this document be in the statutory form, that it be printed on purple paper, and that it's something that you would review with your physician, and your physician would have to provide counseling and guidance on whether or not this should be signed. This is typically going to be somebody that has maybe a terminal illness, would generally be placed on hospice or something along those lines. Most physicians probably aren't going to have this conversation with somebody that's in their 40s and otherwise in good health without any chronic or acute conditions that's likely to cause their death within a short time. People should be aware that in Missouri, there is a presumption in favor of organ donation. If you have a driver's license, it's going to say organ donor on it unless you opted out of that. So again, our healthcare power of attorney recites that Missouri is in fact an organ donor state. And that's a conversation that I have with my clients, that if they don't wish to be an organ donor, then we need to include an affirmative statement that the individual is not to be an organ donor. HIPAA releases, so all of your protected health information, all of your medical information is going to be protected by federal privacy laws. We can do a separate standalone document that would authorize the release of your protected health information to certain family members and individuals that you want to name. This would be irrespective of whether or not you are incapacitated. Our healthcare power of attorney does authorize the release of protected health information when an individual is in fact incapacitated to the attorney in fact. If you wanted to provide this without respect to your capacity, then you could do that. And this is something that's typically done with older couples, individuals that may be in their 60s, 70s, 80s, to where they'd want their doctor to be able to speak freely with their children. Again, you can nominate a guardian for yourself in a healthcare power of attorney. So in the event that for some reason the healthcare power of attorney is not working in the intended manner, then you give an expression to the court as to who it is that you would want to serve as your guardian in the event that you're not able to do so. Occasionally you'll run into situations where a healthcare provider won't listen to the individual under the power of attorney. Other circumstances might exist where you as an individual won't follow the instructions of the attorney in fact, maybe as a result of dementia or somebody suggesting you don't need to be placed in a certain type of a facility, whether it be an assisted or a skilled living facility, and they need to have the court order to be able to keep you in that facility to keep you safe. The other thing, and again, we've kind of talked about this, we can do it what's known as a right of sepulcher. Again, this is just the disposition of your remains. We can do this as part of the healthcare power of attorney. We can also do this as a standalone document. Again, it would set forth an individual's personal wishes and desires as to who's going to be responsible for types of arrangements, as well as giving that individual specific guidance as to what those instructions should be. Some additional resources on what we had talked about this evening. The Missouri Bar Probate Law Resource Guide talks about wills, talks about guardians, talks about the probate process. It's a pretty good guide. I keep a few hundred of these at my office and hand them out during presentations, as well as to clients that come into the office. It's just been a great resource. And then the Missouri Bar does have a durable power of attorney in healthcare, durable power of attorney for healthcare and healthcare directive. There's also a HIPAA release authorization form in there. And these are available for download at the locations that are listed there. And with that, we can open it up for questions, or we can move on to the next speaker.
Thank you so much, Mr. Simmons. Yeah, I will handle the questions at the end. So let's go ahead with Imam Shakir Hamoudi to cover the Islamic perspective. Imam Hamoudi, you can be unmute, and you are already a co-host, so you can go ahead and share your screen with us. So you click on the green button at the end of the screen, where it says share screen.
Yes, okay.
And once you click on it, it will show you windows of different apps that you can share, and just pick up the PowerPoint. While Dr. Hamoudi is launching his presentation, a quick question for you, Mr. Simmons. I think you covered that, but I have a question through YouTube stream. They're asking, is the healthcare decisions added automatically to the will, or it's like a separate addendum to the will? If someone wrote a will without healthcare decisions, is that can be like addended at the end?
I view them as two separate documents. So we have the last will and testament that disposes of property and issues after death has occurred, and then you have the healthcare document, the healthcare declaration, and the durable power of attorney for healthcare, which would be effective during life, and then with the exception of disposition of remains, that would be the only power that would extend beyond death.
Thank you so much. All right, so Imam Shakir, we are seeing your presentation and you are unmuted, so you can good to go if you want.
Okay, give me 1 second.
Okay. We all kind of learning through this technical, social distancing environment.
Yeah. Bismillah ar-Rahman ar-Rahim. Alhamdulillah wa salatu wa salamu ala Rasulillah. I need to go very quick. May God bless you all for attending. This is a great presentation that we have just received from Mr. Simons. I did not expect that to be, that much elaborate, but I thought mine would be more complicated, but I think yours were more complicated. So let me start by saying Islam is a comprehensive way of life that directs individuals and societies to conduct their lives in such a way that fulfills their happiness in this life and in the life after they die. Every soul shall encounter death, and naturally we do not know when to die or where to die. Some will have their books of deeds closed at the moment of death, but others will have more rewards to continue to be added. And we hope that we are from this second category. And one venue of achieving that is through writing a will. In the Islamic literature is called wasiyah. The translation of the dictionary, and I think you used that also, is the bequest, which is the property of or money that you promise in the will to give to another person or organization. The evidence from our text is that from our holy book, the Quran, كتب عليكم إذا حضر أحدكم الموت إن ترك خيرا الوصية للوالدين والأقربين بالمعروف حقا على المتقين. That's Surah Al-Baqarah, verse 180. Prescribed for you when death approaches anyone of you, if he leaves wealth, is that he should make a bequest for parents and relatives according to what is acceptable duty upon the righteous. So it is a very, very brief statement, but it's very powerful that put the conditions of this kind of document. Another verse that when you encounter the death, then you need to have two sane witnesses from you or from among others. The third, and this is from Surah Al-Ma'idah, chapter 5, 106, and from Surah Al-Nisa, من بعد وصية يوصي بها أو دين, after any bequest he may have made or debt. That after the death, you need to fulfill, any loan that was outstanding before the beneficiaries may get their rights. Another statement, but this is the statement from the Prophet, peace be upon him, Abdullah ibn Umar رضي الله عنهما قال قال رسول الله صلى الله عليه وسلم ليس من امرئ مسلم له شيء يوصي فيه يبيت ليلتين إلا ووصيته مكتوبة عنده. It is not befitting for any Muslim who has any wealth to be inherited, that he stays 2 nights, except that his will should be with him in writing. And the narrator, Ibn Umar, said, I did not have a single night after I heard the Prophet, peace be upon him, saying that, I did not have one single night without having my will ready under my pillow. And this is agreed upon hadith. In Islam, differently from other, and that's where we make the connection, and probably we have to really make both requirements match. The will in Islam is more than taking care of the wealth. It's really far more than that. It includes some aspects. I'm mentioning here a few of them. The most important is to affirm one's belief in Allah, the Almighty, the Creator, in His Messenger, in the Day of Judgment, and in every other aspect that Islam calls for. The second point is to remind and stress this belief to one's family, children, and all relatives. And there is here a document, a verse to that elaborate. Chapter 2, verse 133, which is Surah Al-Baqarah, where you witnesses when death approached Jacob. And so remember when the witnesses of when Jacob witnesses the death, he called upon his people, whom are you going to worship after I die? So he wanted, Jacob is the father of Isaac, and the Isaac is the grandfather, the grand-grandfather of Jesus, peace be upon him. So Isaac is the grandfather of all the Israelite prophets and messengers. So Jacob called upon his people, including Isaac, Isaac was the father. So Jacob assembled his children and asked them, whom are you going to worship after I die? And they said, we are going surely to worship your fathers, Abraham, Ismail, Isaac, one Lord, and we are Muslims to him in submission. So this is a very, very strong statement in the book, in the Quran, to give us a guidance that the most important will or portion of the will that we have to spell out is whom we worship and whom our children would be worshipped. The other point is to clear our responsibility of any wrongdoing that our families and children would do after we die. And this is especially important in this country, that when we die, we do not know what will happen in the system regarding our bodies and how to do this or that. So we have to make sure that we are immune if we write our will in the right way. The will could probably spell some benefit for us to be continuous charity. And we have a text for that, that if the son of Adam ceased to exist, then his book will be stopped of adding more rewards, except for a continuous charity, a knowledge that others will benefit from, or a righteous child who would supplicate on his behalf. The other point is that the will protect the rights of others, especially the minors and those who have the right in your wealth. The will, as a legal document in the Islamic law, will cover all the 5 possibilities of the ruling. It could be a must, that you must do the will, and that is if you are in debt, because otherwise, especially if no one knows about this debt except you and the lender, then it becomes Islamically binding on you to write a will. If the person is rich and has non-inheriting relatives, then a will is needed. And then we have a document also to that extent. We mentioned that a few minutes ago. The will may be recommended mustahab in Arabic. If the person is rich, his inheriting relatives are rich, and his non-inheriting relatives are also rich. So he is recommended to make a will for a third party, non-relatives, like an organization, like orphans, like some teaching institution, and so on and so forth. So it is recommended to do that. The third category is undesired, which is makruh, that you are recommended not to do the will. And that is if the person is poor, if you are poor, and your inheriting relatives are also poor. So they are more entitled in what you are leaving behind for them. So you're recommended not to do a will that includes the money, but you may do the will that includes other stuff, especially the kind of belief that you believe in and you want your children to believe in. The will may be unlawful, which is haram, Islamically unlawful. And if the will exceeds 1/3 of the inheritance. In Islam, the individual is allowed to do the will with the amount of his wealth that should not exceed. In fact, it should not even reach 1/3 of the total capacity that he has. And we have a text to that extent. The Prophet, peace be upon him, said to Sa'ad ibn Abi Waqqas, الثلث والثلث كثير. Leave 1/3, and 1/3 even is too much. You need to leave less than that. The final option is optional, or the final characterization of the will is to be optional or mubah. It's called mubah in Arabic. And this is for any case that was not covered in the previous 4 cases. Example is if the person is very rich and his inheriting relatives are in need, he can write a will in the amount of up to 1/3. If his wealth is not much, but his inheriting relatives are rich, then he also may write up to 1/3 of his wealth. So if he has both, if he is rich and if he's not rich, it depends upon what condition his relatives or his beneficiaries are. The will must be opened immediately after death to avoid any confusion, any violation, especially that which are related to excessive sadness, excessive crying, because in Islam that is not recommended. In fact, that is not even lawful. Little sadness, little tears are allowed, but not crying loudly, as we could see in some communities. Other aspects is the salah, is the burial, what to do with the body, the washing, and so on and so forth. But the violations may be in the will itself, and that is where the hairy really details come. And I could not give all the cases, but I am giving here very few. That's why I'm going very fast. The will at the moment of death is not valid. At the moment of death, the will is not valid. You cannot wait until the moment of death and you say, okay, give this amount and give this amount, because it is too late. If his death is more than his wealth, then the will is not valid, is nullified. If he was forced to write his will, then the will is nullified. If he was joking or he wrote the will by mistake, then the will is not valid. The will can be valid by signaling if he could not talk, as long as he is sane, by uttering, or by writing. Three cases the will is valid. The receiving person does not accept the will. If the one who is assigned or the guardian on this wealth say I cannot take the responsibility, then the will be rejected, and then the inheritance Inheritance will take care of that. The receiving person may inherit, will not, will is not valid. So if we write a will where one of the beneficiaries is entitled to your wealth as an inheritant, then the will is not valid, because you cannot make a will for somebody who is going to inherit you. This has some details. I said, well, let me just spell the details. Somehow, if you wrote the will and then it was open, and part of that includes or covers one of those who are entitled to your wealth as an inheritor, then the inheritors will be confused to what to do. If they agree, all of them, to honor your will, then it will be valid. But if one of them objects or more, then it will be nullified. So my advice is you should not leave your children and your spouse and really in a chaos, taking care of this undesired situation. Islamically, you should not do this. But if you do that and they agree to respect you and validate your will, then it will be valid. However, there is another opinion that really prevents that totally. And continuation of the cases, the receiving hand is not defined. For example, well, I will give my cousin 1/3 of my wealth, but you have more than one cousin, so he is not defined. So the will is nullified. But if you describe, for example, I will give 1/3 of my will or 1/4 to the orphans in Columbia, Missouri, or to the Islamic School of Columbia, Missouri. So you specifically describe the beneficiaries, then this is valid. The receiving hand is not qualified. Like, for example, you designate 1/3 of your will to a cat. So this is not valid in Islam. Receiving hand is the person's killer. If somebody kills his father to inherit him, then he will be deprived from anything, any right. The receiving hand is not a Muslim, then the will is valid, is not invalid, it is valid. So it is allowed that non-Muslim will inherit a Muslim. Will is something not lawful. This is haram, that Islamically not lawful. So the will is nullified. So for example, if you want to donate to a wine factory, for example, or to buy a discotheque, or to buy shares in an unlawful firm, then this is not valid and it will not be honored. So the executor will have the right to nullify it. The executor of the will is a lady, that will be valid. So there is no difference really. He wrote the will while his children are poor. So the will be void because your children are more entitled in your money. More, executor of the will is not a Muslim, so this will is not valid. So you cannot assign a non-Muslim because a non-Muslim needs really to educate himself about all these details. So to start with, you should not assign a non-Muslim for that job. Executor of the will stays within his authority. So the executor cannot exceed the authority that the person had written in the will. If he exceeds the authority, then the children or those beneficiaries have the right to stop him by the power of the court. A receiving person dies before the person, then the will is void, unless the beneficiaries agree on assigning another person. But if one of them objects, then the whole will be nullified. The wealth vanishes before person's death, then the will is void. If a house is burned to ground, then, or if he loses in stock market, then that's it. I mean, the will is no more valid. person changes his mind, the will is void. So the person can change his mind all the way until before death, but not until the moment or the hour of death. Receiving hand is a grandchild, while son or daughter are still living. So if your son, for example, is still living and his son is living, you cannot make your grandson as a beneficiary, because your son will block his son from benefiting from your wealth. However, some details: if there is an isolated case where the son is really poor and his children are in need as compared to other sons, and who are the uncles, and if all the uncles agree to this will, to honor the will of the grandfather, then this will go. Otherwise, if one objects, then the will will be nullified. The receiving person is not born yet. However, there are some details. If the lady is pregnant, the person can assign to that womb, to that individual who are still not born. However, if the lady is not even pregnant, then the will is not valid, is null and void. The executor takes this role not by choice. And the only case that the scholars gave is that if you are traveling, two of you, and your friend suddenly dies, and he has you have a lot of information about his wealth, but he did not assign you as a guardian or as an executor. You have the responsibility to assume that role as an executor, to fulfill the right of your Muslim brother. So even if you did not wish to do that, then it becomes an obligatory on you, according to the law of Islam, to be the executor, because Allah says you have to help one another in righteousness, and this is part of the righteousness. And by assuming that role, you are going to prevent the misuse of the wealth and the loss of the rights of some individuals in the Muslim community. Suppose that he did not write a will, but his children, out of the love toward him, they designated up to 1/3 of his wealth as a will. This is valid. In fact, this is good and even preferred. So if those brothers and sisters who are listening, this is really a great portion of our deen, that you can really do that, even if by mistake he did not do this will. Receiving end is not Islamically sound. So for example, he misuses the money. He is not very sound Islamically. He drinks and he womanizes and he does every sin or some of them. Then the executor must really take care of this. He instead has the authority to change the receiving end to a valid one. So if you write a will to a receiving end that is not really a good Muslim, then the executor has the right to change. If you exclude one of your children, the will is void, no matter what that child does, even if he is not Islamically sound. In the previous point, we were talking about the receiving end of the will. He is not one of the inheritants. In the last point, we are talking about one of the children who is an inheritor. You have no right as a father or a mother to exclude and deprive him from your wealth. This is the assignment by the Almighty Allah subhanahu wa ta'ala, this is not your right, no matter what he does. Let him burn his money to the ground. This is not your business. You need to go and meet Allah subhanahu wa ta'ala on a clean page rather than letting your son following you. Will should be written sooner than later. Otherwise, the law of the land will apply at the time of death. You really do not want to reach that crisis. Witnesses and notarization are required to be binding in the court. If a lawyer is involved, it would be even better. Now, I say it is a must after listening to Mr. Simon. Lawyers know the law very well. However, Islamic aspects of the will, as you have seen how many details that it encompasses, the Islamic aspects of the will should be taken from the Islamic Center or an organization, whether in town or out of town. It doesn't matter, even out of the country, as long as it is Islamically sound and correct. Islamic will forms are available online, and I think now the specific details that will pertain to your family should be included, and I have a copy and I can share it with you. But not only that, I think the law of the land, as Mr. Simon have elaborated, talking about it earlier, should be incorporated with those forms. Questions?
Thank you so much, Dr. Hamoudi, for this thorough presentation. In fact, I felt many of the topics went above my head, but we'll try to, for the sake of the time, I think there may be many questions arise from the community about the Islamic perspective portion of it, but I would like to not keep Mr. Simmons with us all the night answering these questions that may not be relevant to him and to save his time. So I'll ask the questions to him first, and after we complete the questions that dedicate to the legal perspective, he is welcome to stay or he's welcome to leave us based on his preference. And I encourage everyone who has legal questions to post them now in the chat box so we can deliver them to Mr. Simmons before he leaves us. So a quick question to you, Mr. Simmons. You know, some families who are immigrants who have extended family members overseas, let's say siblings, parents, and he or she passes away, and then part of the inheritance, according to the Islamic, distribution law, need to be sent overseas to those beneficiaries. How would the law allow transferring big amount of money from US overseas? Yes, you are unmuted now.
Okay. So the will is going to be valid. The beneficiaries are who they are. Hopefully the personal representative is going to know who they are, how to reach them, how to get a hold of them. There could be some tax issues associated with the transfer of property outside the country. Now that's a little bit over my head from being able to speak, intelligently to say, yes, this would definitely happen. But there would be some issues associated with that.
Okay. All right. Another question about if a person passes away and he or she does not have a healthcare portion in his or her will, what's going to happen to the body? Is it going to go by default to autopsy or be like not buried in the Islamic way? Who will taking control of the body after death if there is no healthcare plan in the will?
So if there's no healthcare directive that's in place, then typically the funeral homes are going to talk to the family members. And if there's some sort of a disagreement among the family members, then the individual who's going to volunteer to pay for it is typically going to be given preference or priority to make those decisions. The statutes are out there, that would identify those, but a spouse is not necessarily going to have superior rights to an adult child.
Okay. So another question for you, Mr. Simmons, in case I wrote my will, I have like a couple of witnesses who signed the will in the presence of notary public, and then a few years later, I have decided to add an addendum or change part of my will. Do I have to go through the same legal process and get the witnesses and stuff like that, or can just add addendum written in the bottom of the will?
So if you're going to do an amendment to a will, that's called a codicil. I typically don't do codicils anymore because if the client's going to be returning to me, I can simply make the changes on the original, change the date, we can re-sign it and execute it so we don't have two documents or more. If somebody who's done one somewhere else and they're asking me to make a change, again, generally I will just do a new document rather than a simple codicil. There could be circumstances that would dictate, yes, do a codicil versus just a new will. The amendment or the codicil does have to be executed with the same formalities that the original will does to be valid. So statement of testamentary intent signed before two disinterested witnesses, before a notary public with the self-attestation clause and everything, and the self-proving clause.
Okay. Well, again, for you, Mr. Simmons, now you heard what Dr. Shakir said about the Islamic way of distributing the will and how inheritance is distributed based on certain portions of the living inheritance. Is it okay from legal perspective if one says, I authorize the Islamic Center to distribute my inheritance based on the Sharia law or the Islamic law, and that's it? And the committee, whoever the committee in that Islamic Center will look into all this, opinions and make the math and distribute and give the advice how to distribute the inheritance based on that. Is that accepted legally to be brought in the will without specification?
I think it can. That's not really my preference. I've been involved in circumstances in which property was left to an individual for simply welfare. And what the document meant by that was to identify, maybe some public charities that the will makers had benefited in the past and or would generally fit within their wishes. I felt that there was some ambiguity there, and I never really felt comfortable with that. But I don't think that it's something that could not happen, because I think that the proper way to do that would be to basically leave a charitable bequest to the Islamic Center of Central Missouri to be distributed in accordance with the particular tenet of faith, and that would be perfectly fine. We do that all the time with other charities. I would see no reason why we couldn't leave it in that circumstance and rely upon the imam to make that decision.
Okay. And once the person says, I authorize the committee in the Islamic Center to decide how to distribute my inheritance, no one among the inheritance can object and say, no, I do not agree. This is my right. This is my portion. Since the deceased person already declared who is in charge of distributing the will, that should be it, right?
Almost. A surviving spouse has a certain right to receive an inheritance. So you can disinherit anybody other than a spouse. And as long as there were some assurances that the spouse was going to receive a certain minimum level of property, then yes, that would be valid.
I see. Right. Mr. Simmons,
Can I ask Dr. Muhammad, if the spouse is also in agreement that the wealth will be distributed according to the Sharia, will that be a violation of the Missouri law?
No. So the spouse has a right to elect against the will. If the spouse does not, in fact, elect against the will, then it's not going to be a problem. again, general rule of thumb, I suppose if you had a situation where the surviving spouse were in a situation where they could not afford to pay for long-term care or something along those lines, then they may have to elect to protect the other tax-paying citizens of Missouri. But it's an option. With rare circumstances would it not apply.
I do have a question for childcare. Let's say a single parent who passes away suddenly and they have no preparation who will take care of the kids. What is the legal consequences? Where do they go if they're minor?
Typically what's going to happen, and if we have a child that's in need of care, nobody able or willing to step up, then the Division of Family Services is going to step in and do a foster placement until an appropriate kinship placement or something else can be determined.
If someone wants to, proceed with proposing a will with you, Mr. Simmons, what will be the process? How long it takes, and how much does it cost?
Okay. So for new clients, we do not charge for an initial consultation. At that point, the process is they would contact the office. They would indicate a desire to meet with me or another member of my firm. At that time, a welcome packet would be sent to them. We would collect some basic information. We'd want to meet with them. At that point in time, we would find out what their specific needs are, what it is that they want to do, and how it is that it needs to happen. And then we give a specific estimate based on those facts and circumstances. It's really hard to say what something's going to cost without knowing the specific circumstances. If we're simply doing a will and nothing else, it can be, $400 to $500. If we're going to put in powers of attorney, it can go up a couple hundred more. Sometimes wills and trusts make sense, and just having a full understanding of what the facts are. But again, it's not a sales pitch to say it's hard to say. We provide that a free initial consultation so we can learn more about what that client needs, what works for them, and then tell them what it's going to cost.
Okay. So just to clarify, it is 400 to 500?
Again, that's on the very low end, but sometimes, and again, this may not apply based on some of the things that I learned this evening. Sometimes individuals don't need a will. Again, I think that's probably against the teachings of Islam as I understand them. Everyone should have one, but again, that would be on the low end. And typically we're going to recommend that they have powers of attorney in place as well. And we want to talk about non-probate transfers, and joint ownership and things like that.
Many people asking about your contact details, Mr. Simmons. Can you share a screen with us showing your contact info?
Yes. Maybe.
Yeah, you should be able to share your screen. Dr. Shakir, can you stop sharing your screen?
Yes.
At the top, yeah. Here we go. So, Mr. Simmons, you can share yours. Give it on the phone.
There we go.
All right, here we go. Yes, so participants, you can take screenshots and save this into your favorites. I'm calling one more last time for the participant if they have any questions to Mr. Simmons before he leaves us. Unless you want to stay and hang up with us, I think there will be most of Islamic questions to Dr. Shakir. By the way, Mr. Simmons, what is your opinion about what you heard from Dr. Shakir about the Islamic law and inheritance? I think this is too much details that even many of Muslims do not know, but the concepts, how does it look like to you as a non-Muslim?
I've had an opportunity to sit in on some continuing education on various faiths and how they treat these types of matters. It's consistent with everything that I've heard. He thought my concepts were new and difficult to learn. I find these to be something that's new. But again, I think it's in part just based on familiarity. I believe that, you know, they're perfectly valid, and for those that, you know, want to be devout Muslims, then this is something that they should consider. And as an attorney, if the client comes to me and they have something that they want to accomplish, it's my job to make that happen. So, I mean, I think that it's a good thing. Everybody is going to die. Being able to find comfort in knowing that your situation is taken care of in the way that you want it to be taken care of is important. And that's one of the reasons that I do the type of law that I practice is that I want to help people accomplish their goals. So I think it's very helpful to have the education, because I think a lot of people don't necessarily understand it. It's a difficult thing to grasp, and you know, part of that is just the subject matter, and part of it is just an unconscious bias to not want to have to confront your own mortality.
Perfect. So as part of the planning is what we see occasionally in the weekends across the town, the estate sales. Are you guys managing the sales after someone's passed away?
Can you repeat that, please?
Yeah, so I just learned when I tried to prepare to this workshop that the estate is the term for this death planning. So I made the connection that when I see the signs estate sales, when people like sell their home furniture in a weekend, is that something that also arranged by you guys or by separate agencies?
Those are separate companies. They deal with estate sales, so somebody's passed away. It doesn't necessarily mean that somebody's passed away. It could just mean that maybe somebody's going into a smaller living environment, and where they were before, now they're downsizing and selling all the things that they no longer need. So it's viewed as an estate. It's everything that they own that they're not going to keep, you know, with the exception of the personal effects.
Right. I do have a question here about if single parent or both parents pass away, like in car accident or suddenly, and the kids are minors, and no one step in, then the child protection service will take responsibility. If someone volunteers from, let's say, from the neighbors or from the Islamic Center and want to take care of those kids and take custody, is there any specific requirements for those people? Do they have to be certified, like foster parents, or any way to just someone volunteer, hey, I can take care of them or something like that?
That's a little bit out of my practice area. I don't do much family law. It is my understanding that for there to be some sort of a emergency placement, it's going to be with a licensed foster care parent. So the ideal situation would be that those family members do recognize the need to provide for a minor child or children, and that they designate or nominate a guardian in a last will and testament. At that point, something happens to the parents, then the neighbors can get the child, they can take care of them, and then they can take immediate steps to get appointed as a legal guardian.
Even if this legal guardian is overseas, like let's say in the will, the parent assigned that my brother or sister overseas will be in charge if I pass away. So is that okay? I mean, to transfer kids overseas?
You can. They would have to establish the guardianship, I think, in Missouri first, because that's where the child's located. But once the parent's will is admitted to probate and the guardianship hearing is held, then yeah, I think that's probably going to be the proper thing to do. It's not going to be something that happens in 2 days. It's not going to be something that happens most likely in a week, but it is going to be something that can and quite frankly should happen, because a parent should be able to designate who's going to take care of their children.
Gotcha. Great. Perfect. So again, if anyone have any question, they feel free to raise your hands, and you can ask the questions verbally to Mr. Simmons. Otherwise, I think I covered all the questions in the chat box that are dedicated to you. If no more questions, again, Mr. Simmons, you're welcome to stay with us. I think all the other questions will be Islamically related. Feel free to stay with us, or feel free to enjoy the rest of the time with your family. On behalf of the Islamic Center of Central Missouri and the Muslim community in Colombia, I would like to extend my extreme thanks and appreciation to your time and effort. Thank you for educating us about this important topic that I personally have zero information about. So thank you so much for enlightening us this night, and wish you all the best.
You're welcome. If there are additional follow-up questions, you can certainly email me. I'll respond as I'm able. I think I will go ahead and drop off the call. Again, thank you for the opportunity. And if I can be of any further assistance, please let me know.
Will do. Thank you so much.
You're welcome. Have a good evening.
You too. Thanks. All right. So back to you, Mr. Shakir, Dr. Shakir. So we have a bunch of questions to you. Let me start from the first concept of.
Let me go back to the sharing.
Okay. So while you prepare your presentation, so you mentioned that the Prophet ﷺ taught us that if one want to make a will, he should or she should abide to a third. So assuming that the rest of the wealth, the rest, the 2/3 will be distributed according to the inheritance law in Islam, right?
Yes.
So put us in the presumed scenario, like the classic, most of our Muslim families here. We have a couple, husband and wife, let's say with 3 children, 2 boys and 1 girl, for example. And the father passed away, okay? And he left behind $100,000, a house and a car, okay? How will the inheritance be distributed? If
so this session is not to distribute the inheritance, brother. That needs another session.
That's a good point.
But tell me about the 1/3.
Yeah. So let's say that the person mentioned that 1/3 of my inheritance will go to the Islamic Center.
For example, yes. So the rest will be according to the, if you have a wife, then she will have, and you have children, she will have 1/8, and the children will have للذكر مثل حظ الأنثيين. Yes.
So can I, in the perspective, I mean, can this parent who thinks that the daughter will inherit less than the boys, and the situation in the US may be unstable for a Muslim girl with hijab and stuff like that, so he decided to dedicate part of the will to her more than her siblings, boys. Is that permissible to be part of the 1/3, to go like 1/6 go to the girl and 1/6 go to the masjid, for example?
No, this is, I mean, this was covered by the cases that you cannot, لا وصية لوارث.
Okay.
Yes, the one who inherits from you should not be part of the will, period.
Okay.
Yes. And you cannot deprive one of your children, and you cannot give him more than his share or her share.
Okay. Gotcha. All right. Let's go back to some of other questions. Why it is makruh for a poor person to make a will?
For a poor person to make what?
Will?
If your children are in need.
I see. Okay.
Okay, and you are poor, so because the Prophet ﷺ said to Sa'd ibn Abi Waqqas after he came and he said, I have only 1 daughter or 2 daughters and I'm going to die. SubhanAllah, he ended up not dying. So he said, أن تذر عيالك أغنياء خير لك من أن تذرهم فقراء. So to leave your children well off, wealthy, better than leaving them poor.
Right.
So this is the case where it is, you know.
But that takes me to the other part of the question: why it is not allowed to give more than 1/3 as a will?
That is in the same hadith of the Prophet ﷺ. So Sa'd ibn Abi Waqqas told him, I can, because I have only, you know, 1 or 2 daughters, and probably they will not need all my wealth. They are going to get married and they will be living with their spouses. They will spend on them. So what should I do? So he was consulting the Prophet ﷺ what he should do with his wealth. He said, should I designate 2/3 for the charity, for example, and leave them one? He said no. He said, how about 50%, half, nusaf? He said no. He said, how about thuluth? He said, الثلث والثلث كثير. In fact, many of the scholars among the Sahaba, including Ibn Abbas and others, they said, try your best to be a little bit below the third, because the Prophet ﷺ said, الثلث كثير. So this is the text. It was agreed upon hadith. So the third, the up to 1/3, but I mean 1/3, you are not going to be a sinner, but in case you have something that you are not aware of, and then you will exceed. So try to give less than 1/3
So
to the designated well or person.
things in the US are more complex. So, you know, after that, there is very expensive, maybe bill for funeral, there is expensive health care bill, there is insurance, there's a bunch of expenses that happens after a person passed away. So will that amount be deducted from the Ras al-Mal, from the whole inheritance before distributed to the inheritors, or it will take away from the will?
Yeah, Jazakallah khair. I think at one point, maybe after Ramadan, we need, because I really had the intention to do that for a year now. I would love to maybe share with you some of the inheritance law of Islam. It's a beautiful law. The priority after one dies, the priority is to prepare the body and bury it. That's the priority, no matter how much it takes.
Okay.
If anything is left, then the second priority is those lenders. If you are in debt, then the money should go to them first. And then, if any, of course, that includes the dowry, the deferred dowry of your spouse.
Mm-hmm.
If anything is left, then it will be distributed among the beneficiaries, those who have the right to inherit you. Yes.
This is before the will or after the will?
Sorry?
So all these rights will be distributed before the will?
Yeah, yes. The preparing the body and burying it, then giving the lenders, and then including your spouse, and then and only then you will go. Suppose that he does not have enough to cover the funeral, then it becomes part of the Muslim community responsibility to do that. And how about if he still needs to give the lenders, then he would continue to be accountable by Allah subhanahu wa ta'ala until somebody pays on his behalf. Subhanallah. It is very, very serious situation. So maybe in the Islamic Center, probably if we can put another box for these kind of fatalities, for these kinds of very, very difficult situations where we can relieve our brothers and sisters in the Day of Judgment, the sooner the better.
I see. Speaking about debt, if someone passes away with a large debt and he left no money behind, and basically no inheritance, and is it the responsibility of his inheritors, his children, to pay his debts?
Yes, if he has children, it is this, of course. The Prophet ﷺ says, Al-ghunmu bil-ghurm. Al-ghunm means you are a beneficiary, and the ghurm is that you pay. So if you are a receiving hand, then that person that you receive from, if he is in debt, if he is in need, then you have to pay on his behalf. A similar situation for the usba. For example, if somebody kills, then his male relatives in the tribe, the immediate first, are responsible to pay, the compensation for the other tribe or for the other family. So that's why they said al-ghunmu bil-ghurm. If you are benefiting from this relationship, then if the situation is reversed, then you have to, live up to and pay on. Yes. So the children will have to be able and will be responsible. Suppose that he does not have and they are not able, then the Muslim community. In a Muslim state, then the state should take care of that.
Interesting. Will be there any punishment for the deceased if there is a debt in his neck, basically, and his children cannot or did not pay the debt?
Definitely, he will continue to be held, even if he deserves al-Jannah. Subhanallah, he will be at the door waiting. Subhanallah, and that's why it is really great for Muslims. Subhanallah, I heard about 2-3 years ago, somebody, I don't know from which country, heard that Al-Imam, subhanallah, Al-Imam Ibn Hazm did not have the chance to make Hajj. So this individual made Hajj on his behalf, subhanallah. So this, the community really should live up to those needs, but he himself, to start with, should not have put himself in a situation where he would leave this life in debt.
Jazakallah khair. Okay, so there is a question from Dr. Nabila Khalil. I really do not understand the question. I will read it as such, and if I was able to clarify the question, I would ask Dr. Nabila to raise her hand and unmute it. So she mentioned this may be too detailed and not appropriate for this forum. If someone makes their money in a non-halal way, you are the executor. Do you have to distribute the money? Is it okay to distribute the money that was not acquired in a halal manner?
This question is clear.
Okay.
The haram way is on him, on the person who was involved in the haram transaction.
Okay.
The inheritance, they receive that money, it is halal on them. That's why the loser is the one who loses his akhirah, his hereafter, for a small benefit in this dunya. But the one who is even in more danger is the one who loses his akhirah for the benefit of others. To benefit your children, you are involved in a haram transaction. So that should not have happened. So yes, sister, if my answer is clear, otherwise I would elaborate more, inshallah. If Saif has a question, I'm ready for him.
Let me see. Definitely have legal sense. This is according to Sharia law, I think should be emphasized. So, what is our current policy in the masjid, Dr. Shakir? Do you have? I know we've been talking about creating a template about Islamic will, and actually I forwarded the template to Mr. Simmons to review it from legal perspective, and I can tell why he did not reply to me. There is a bunch of issues required on the will, and this is their field. They cannot offer this for free. But it's obviously we need to create our own form or template in our masjid that will make it accessible to the community. Just fill the formats and make it ready for them. Inshallah, we need to elaborate more on that and make it available sooner than later. How about if I do want my whole wealth to be distributed to my legal inheritance, wife and children? Is that permissible? In this case, do I need a will? Okay, so someone wants to all his money go through the Sharia way of inheritance. Does he still have to have a will?
he will have a will regarding his body. Okay, because there's a lot really to say. I have wills that are written in Arabic, and there are so many articles that comes before the will, and I advise really everyone to include that in the will. So the will does not necessarily cover the wealth only, but it also covers what will probably protect you before Allah subhanahu wa ta'ala on whom do you worship and how you worship, and you want to immune yourself from any mistake that your children after you do, and so on and so forth. This is one thing. The other thing is you can simply just say, I want my wealth to be distributed according to the Sharia. In fact, there is a fatwa lately where you can make the will as if you have distributed the wealth. I mean, you know your children and you know your relatives, and you consult somebody who knows how to distribute that, and you write the will accordingly. But the danger here is you do not know who will die first. So that is really, yeah, but you can do that. Otherwise, you can just simply say, I want my wealth to be distributed according to the Sharia.
Jazakallah khair. Any questions to Dr. Shakir? Feel free to raise your hand and I can unmute you. You can speak clearer. All right. While waiting for questions, quick reminders tomorrow. Do we have the Dr. Merawad's program tomorrow?
Tomorrow, no.
Wednesday?
No, last Wednesday was the last one. Tomorrow, yeah. Tomorrow we don't have.
We have no programs until Ramadan, inshallah, which is going to be the first event on Thursday night.
Thursday night and Friday reminder at 1.
Yeah. So Ramadan, inshallah, will be Friday, April 24th. And on the April 23rd, the Thursday night at 9 p.m., we will have our first Quran Juz' recitation by our reciters. So it is not a substitute for the Taraweeh. You are responsible for praying Taraweeh at home. You can just listen to our reciters and follow up the Juz' that you prefer to read. In case you cannot recite fluently, you can join virtually through Zoom. It's going to happen at 9 p.m. inshallah on Thursday. Please register on the ICCM website, put your email to receive newsletter, and also subscribe to the YouTube channel because most of the events will be streamed live on YouTube. If you do not have the YouTube website, you can scan your this code on your phone. It will take you to the YouTube channel, and you just click on subscribe and notification, so you get notified whenever any event happens. We are currently streaming live on YouTube, so this is basically, you know, what you can see on the screen. I will stop sharing the screen so Dr. Shakir will go back to his screen. All right. The recitation will be on YouTube only, so we're not going to stream the recitation on Zoom. So you don't have to subscribe to Zoom. You just go on YouTube at 9 p.m. You're going to see the recitation there. Okay, brother Sheikh, you are unmuted.
Yeah. Yes. Assalamu alaikum, brother.
Alaikum assalam wa rahmatullah.
Brother Shakir, I think I may know the answer, but I was consulted about this question. There is a situation where a deceased person had 2 houses. He left 2 houses. And he said that he was going to give 1 house to his 2 daughters because they were taking care of him. And he knows that his sons would not take care of them if he leave them the equal property. So he gave the other house to his 3 other sons. But the house that he left for his 2 daughters are of a higher value. So it is legal. Of course, I said it was not legal. That's what I thought, but.
We have so many, I mean, you can see so many cases in the literature from the same category. And the answer is absolutely, he's making a big mistake.
Yes.
Toward his akhirah. He should not do that. Yes, one of the daughters or both of them were taking care of him. I advise them, I really advise them to make ihtisab, to hope that Allah subhanahu wa ta'ala will compensate them in the hereafter, and let the law of Islam to take effect, inshallah.
So should they return the property?
They should at least, I mean, it is not something that is movable to return, but they should at least sit together with their brothers and value those two houses and divide them. And if the brother decide that those two sisters will continue for some compensation, then they can do that. But at least they have to be in agreement. If one of them objects,
yes,
then they have to sell both houses and divide them accordingly.
If the brothers agrees, is it okay? If the brothers agree,
if the brothers agree, then this is their wealth. They can donate to their sister. This will be great. Yes, if they do that.
Okay, but I think they agree. They never raise a question, but still I thought it was not legal.
They have to agree from heart, because they probably would find it very awkward to kick their sisters in the street, but at least they should go there to the sisters and tell them, hey, I mean, we are agreeing, but I mean, we have really no choice. So, okay. I mean, but for the brothers, really, I advise them, if that is the case, these are their sisters, and where would they go? If they are well off, then they could buy another place for them and divide both properties accordingly, because this is not worth to go and meet Allah subhanahu wa ta'ala and you are in debt, especially in debt violating the law of Allah subhanahu wa ta'ala. This is something knowingly you are doing that.
Dr. Nizam has a question too.
Yeah, assalamu alaikum. I thought I could ask that attorney a question, but anyway, Brother Shakir, the question is, we know that the boys and daughters, son and daughters, according to the Sharia, they get from father. Is the same if the mother leaves some property? Is the distribution same way, or they get equal share?
Yes, it's the same way.
Same. So 2 is to 1.
للذكر يوصيكم الله بأولادكم للذكر مثل حظ الأنثيين. And يوصيكم is an address to a second person, male and female, that الذكر مثل for boys are double for the girls. Yes, if they inherit from the mother or the father, the division will be the same.
Okay.
However, yes, inshallah, when we discuss the inheritance issue, you will see how many cases in the Sharia where the ladies take more than the men. But that will, inshallah, we differ that later. Yes, right. Go ahead, Brother Nabal.
No, Brother Muhammad, you said it in the ISNA website for many years. That template is there, so people can get benefit from there. You don't have to reinvent. It is there already for many years. If you go to ISNA website, it's there how to write a ISNA, Islamic will, or the living trust, both of them there. That's okay. Khair, jazakallah.
Any more questions? All right, let me go back there. Any questions? All right, so I think we are done for the day. Jazakallah khair. It has been a long night. Thank you so much for tuning in. It has been almost 2 hours now. This is recorded and streamed on YouTube. As I said, it's going to be available whenever you guys want to review it. I think we all need to consider the will. It is a really important subject. And alhamdulillah, I think we get some knowledge about the topic today. I was really, I have zero idea about what's going on. So alhamdulillah, we get some enlightenment about that, and hopefully we will come with a policy. And I will look up into this template through ISNA website. I will make it available through our resources. Again, please stay connected, subscribe to the YouTube channel, follow the Facebook page, review the activities on the ICCM website, and put your email to receive the newsletter every now and then. Jazakum khair. Thank you so much all, and Ramadan Kareem everyone. سبحان ربك رب العزة عما يصفون وسلام على المرسلين والحمد لله رب العالمين. جزاكم الله خير والسلام عليكم ورحمة الله.
السلام عليكم ورحمة الله تعالى وبركاته.